Welcome back. The Oxford High School shooter is back in court as an Oakland County Circuit judge hears arguments in a Miller hearing.
Now, this is a special hearing for minors, a result of the 2012 Supreme Court ruling, Miller v. Alabama, that said mandatory life sentences without the chance of parole are unconstitutional for minors. At the hearing, the prosecution presents evidence and testimony they believe amounts to exceptional circumstances and makes the minor eligible for life without parole.
Once both sides call all of their witnesses and make their arguments, the judge will decide. Here with us now are 36th District Court Judge Kenneth King and retired 3rd Circuit Judge Vonda Evans. Thank you both for being here today.
Thank you for having me.
Absolutely. Can you start with telling us from the judge's perspective, how does this differ, a Miller hearing from a criminal trial? What needs to be proved?
Well, first of all, because this is a very unique hearing, there is science that says that a juvenile's brain has not completely formed. So there is a rebuttable presumption that the prosecution has to show that he shouldn't have life without parole. So at this hearing, the prosecution bears what we call the burden. They go first, showing why he should have life without parole. And that's why they go first, because it's their burden. If they fail to give notice to the defense, then you automatically can have to sentence him to a term of years, 25 to 40 on the low end, with the maximum not to exceed or no less than 60 years. So it's a notice situation, and basically what they're saying is, listen, you can't do juveniles the way that you do adults.
So essentially what the Supreme Court has done is done away with the cookie cutter approach, whereas we sentence everybody, regardless if they're an adult or a juvenile, to first-degree murder, premeditated without the possibility of parole, life without the possibility of parole. So now we consider factors in determining if this juvenile, if there's some hope for them, if they can be rehabilitated, or if they should in fact be sentenced to first-degree murder, premeditated, and do the rest of their life in jail without the possibility of parole.
And what you have with adults, you don't get to hear all of that. It's mandatory. Here, the judge has to look at a number of factors, age, maturity, but the most important is irreparable corruption. Hey, throw him away, he's garbage, you can't do anything with him. This young man has no prior record, and there's significant evidence that there was a mental health issue that the parents did not see about. So it's a lot, and that judge has to make that finding.
Yeah, so the tricky thing though is determining whether or not, if this person is released after a number of years, if they still pose a danger to the community. And I think the prosecution is trying to lay out a case addressing each of those factors that the judge is supposed to consider. They're trying to show that this person has an insatiable thirst for violence. And they've done that by reviewing his diary and messages that he sent to other people about what he's done in the past in terms of killing birds, and how his plan was well thought out, and he pretty much followed it to the T in terms of how he was going to kill and what was going to happen. The research that went into, if I get convicted of first-degree murder premeditated, what's going to happen to me? Am I going to do life in prison? Well, yeah, I can do that. So it looks like he really thought about his consequences before he took the actions that he took.
So when you hear what you heard today, you heard those audio tapes the day before this deadly mass shooting. I mean, he was well thought out, and even though his brain may not be developed at the age of 15, he seems very calculated here, as if he knows what he's doing, in the sense that he's believing he could change the world here. So did you hear enough today to say he deserves a life sentence without parole?
Well, keep in mind, we've only heard one part of this hearing so far, the prosecution, and they've done their job so far. And I think they have a lot more witnesses to come forward, but they've painted a picture that this is a very troubled kid, but a very dangerous kid as well. And this kid, there's no saving this kid, that we should sentence him to life without the possibility of parole.
And you know, you said, well, you know, there's no brain development. There is science that says the part of judgment in your brain to really think about it and not act on it doesn't develop till you're 20. So what we have to be able to do is, this is first-degree murder. Okay, so it's not like it's second-degree murder. Premeditation, deliberation, yes, those are elements. He's pled guilty to them. But what you have to do, they're balancing factors. It's just not one thing, okay? You have to look at his age, family and home environment, circumstances of the homicide offense, transient immaturity or irreparable corruption, and the possibility of rehabilitation. There's just not one thing. We know, hands down, beyond a shadow of a doubt, this was a terrible situation. People lost their lives and were seriously injured. That's not the issue here, and I think everybody can agree that's not. It's the issue is what do we do with this person as a result of what this heinous crime that he's committed.
Anybody that was viewing the people's case that they laid out today would be enraged, and their hearts really go out to the victims, the families of these victims. And their case is pretty compelling, though, when you think about, like Judge said, it was well thought out. It appears though he weighed the consequences and that he researched on Google what is the maximum penalty I can get in Michigan. And he even told us what he was going to do, who he was going to shoot first. I want to shoot a pretty girl, and then so she could suffer like I suffer. So he's crying out, and he even indicated that as well, that if they just sent me to the office, maybe I could get some help. So those are the kinds of things that the judge is going to have to weigh in making his decision. Is this a kid that can be helped? Or is this a kid that is just so dangerous that it's a risk putting him back out on the street at some time in the future?
And what's really interesting is the Miller v. Alabama case is that particular young man was resentenced to natural life without the possibility of parole. But so many people who have been in prison are now free because of this case. Right. So it's not like because you commit a crime like this, you automatically go to prison for life. There are a number of people through these hearings that have been shown to say, listen, you know what, 45 years, 50 years, 60 years, it's enough. You deserve an opportunity to be back in the community.
I always like to use the analogy of that person who participates in a crime as an aider and abettor and the lookout. And another person goes in and shoots and kills someone. But because you're an aider and abettor, and the aiding and abetting law says any amount of aid or assistance you give another in the commission of the crime, you're just as guilty as if you pulled the trigger. But if we take a step back and look at a juvenile in that role as being the aider and abettor, and that person, let's say that person was an adult that went in and shot and killed someone, do we really want to sentence that juvenile to life in prison without the possibility of parole for being the lookout for making an immature decision that's going to affect them for the rest of their lives?
Well, Judge King and Judge Evans, thank you so much for your time today. It really helps to understand exactly what Judge Rowe is facing and what he has to consider here. Of course, we do have another day, possibly multiple days left in this case, and our coverage will continue. Thank you both so much.
Thank you so much for asking.